The Economic and Financial Crimes Commission is in focus today on Law Weekly. We talked to the head of legal and prosecution of the Lagos Zone, Mr. Gbolahan Latono. We also have our usual recap of the top trending legal stories. Hello and welcome to the program. I am Shola Sheyeli. The recent exchange of words between the leadership of the Nigerian Bar Association and the EFCC has once again put some attention, rightly so, on the EFCC and its work. The Commission recently opened up its detention and medical facilities to the media, some lawyers and members of the civil society. After that tour, I had a chat with the head of legal of the Lagos Zone, Mr. Gbolahan Latono. I began by asking his views on the exchange of words between the Commission and the leadership of the NBA and why the Commission was strongly opposed to giving up its prosecutorial powers.
Well, statutorily, the EFCC, under Section 13 of the EFCC Act 2004, is embedded with the powers to prosecute offenses, economic and financial crime offenses. You have the creation of a legal unit under Section 13, which is charged primarily with the responsibility of prosecuting economic and financial crime offenders. Then don't even forget that the Constitution too recognizes the existence of other prosecuting bodies outside the Attorney Generals of the Federation and of the states. I would refer you to Section 174 of the Constitution that talks about the powers of the Attorney General. Under that, some subsections under that section recognizes that there are other bodies that could prosecute, but that the Attorney General can take over and discontinue prosecution initiated by such other bodies. Among that bodies are the EFCC, the ICPC, the NDLEA, the NAFDAC, the Customs, even the Civil Defense. They all have prosecutorial powers. And we believe we are all working on the same page. We are all organs of the executive. So to us, we do not agree with that position that the prosecutorial powers of the EFCC should be whittled down or should be scrapped or should be taken away.
One of the reasons that some people have put forward for this suggestion by the NBA is that some of the cases by the Commission are not well investigated and then they end up being thrown out of court. And some people think that this is because the EFCC is overworked and not properly funded. And that so if we limit the EFCC only to intelligence gathering and investigation, perhaps there will be better efficiency.
My take on that is that these people are not sufficiently informed of some of the underlying reasons why the EFCC was established. One of the first things you need to note is what was the position pre the establishment of the EFCC. You had a situation whereby the police were investigating cases with the greatest respect to them within the confines of their ability. These cases, they were there investigating. At the end of the day, the case files are forwarded to the State Ministry of Justice. The challenge was that they were not under the same roof. And as of today, that challenge is still there. You find most state councils in court. They go to court to attend to almost 10 cases, and none of these cases go on. Why? The IPO, we don't have control over them. It's not here. We don't know where the witnesses are. The EFCC came on board as an all-inclusive policy. What in MPP, modernized professional policy making, is called a join-up procedure. Bring everybody on board so that you could streamline this issue. That is why you find out we seamlessly prosecute our cases. Our witnesses are ready. The IPO works with us. We work under the same roof. In fact, most of our cases are investigated with the prosecution being on board from the beginning. We adopt the ICC model of prosecution-guided investigation. Then, secondly, when you say the EFCC should be disengaged of certain things, are you not taking into cognizance that this organization came into being as a result of the fact that Nigeria is a signatory to certain international conventions, among which is the UNCAC, United Nations Convention Against Corruption 2003, that calls for the establishment of such a body with such composition So if you are saying, oh, move the organization from the present status and go to another status, it means you are saying that Nigeria should refuse from discharging its obligation, which it has already ratified. Secondly, you are saying that the constitutional provisions itself should be amended, that recognizes the existence of bodies that have prosecutorial powers, and which has been interpreted severally by the Supreme Court in so many cases. The latest being the case of Saraki versus Federal Republic of Nigeria, where the prosecutorial powers of the EFCC as well as other agencies of government were found. So then what is the basis? Is it that the organization is not acting according to expectations? Within this year alone, with every sense of modesty, the Lagos Zonal Office of the Commission, within January 1 and July 15 or thereabouts, when the court went on vacation, we have successfully concluded and obtained conviction in 45 cases. I want you to undertake a little bit of research. Go to all ministries of justice in the Federation and possibly at the Federal Ministry of Justice, and please get their own record of convictions too. We are expecting that by the time the court resume, we are going to have much more. And when you compare that with all the zones, so what are we talking about? Do you change a winning team?
Another reason that some people have given for this suggestion that the EFCC be stripped of its prosecutorial powers is that on the part of the EFCC, there appears to be a selectiveness of prosecution. What would be your response to people who think like that?
I am a public servant. I'm not a politician. And I'm trained as a lawyer. When investigators finish their investigation and these cases are sent to the legal unit here, we have a 3-layer process. It comes to the head of legal. I first vet, I read through, and I forward to the head of teams who are assigned to officers under them. So at the beginning, I'm sufficiently informed about the case file. By the time it goes to the team leader, he too is sufficiently informed. So by the time the legal opinion or the charges is being rendered by the legal officer in charge, it goes through the same regime, the team leader, before it comes to my table. We are not saying we are infallible. In fact, the Supreme Court itself has not laid claim to that. But within human limitations, we are built in some system of checks and balances to check this aspect. What I look for is whether there is a prima facie case via which I can profile charges and go to court. Once I have that, I don't know the color of the Nigerian. I don't know the religion. I do my job without any fear or favor. And for those who say that, I challenge them to produce one case whereby somebody has sued and successfully obtained judgment against the commission for malicious prosecution. I challenge them, let them produce one case whereby somebody has said, oh, EFCC took me to court, and what they did was predicated on malice. As a result, I'm suing them for that, and this is the judgment. People have filed fundamental rights, enforcement right against us. We've gone to court. You are aware of the Stella Udua case? It was discharged in favor of the EFCC. You are aware of the Kingsley Puku case? It was discharged in favor of the EFCC. So severally, we are sued every day, and we do respond. And if the law court believe we are doing our job efficiently by discharging all these frivolous cases against us, then more or less we do not believe that what we are doing is not right. The law court is an unbiased empire. And if the result we are getting is the feelers we are getting from there is that we are doing a good job, an independent entity, which is not under the executive, then we are gratified. And if Nigerians says we are doing a good job as well, it gives us a measure of confidence to continue to do what we are doing.